We are on the record. This is ERD case number CR 2018-02354, Sherry versus Froedtert South. This is the second day of hearing in said case. We were set to begin at 9 a.m. this morning. It is now 10:38. I'm sorry, it's 10:39. We had a small delay this morning at the request of Ms. Krakowski. The complainant agreed to that delay. And so now we will get started. May I have the parties' appearances for the record, please?
Could I just add that the delay had to do with an emergency with my 12-year-old type 1 diabetic daughter?
Yes, that's fine.
Thank you.
Right. So may I have the parties' appearances for the record, please?
Alan Olson and Associates on behalf of the complainant Charney Sherry. Charney Sherry appears in person.
And Attorney Debbie Krakowski appearing on behalf of Froedtert South, like we were yesterday.
Okay. When we concluded yesterday's day of hearing, I believe the complainant had called Susan Ventura adversely, and you were still in the midst of your questioning, correct, Mr. Olson?
That's correct.
Okay, so we will start back up with Ms. Ventura. Ms. Ventura, I'm going to have you give an oath again, okay? If you'd raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ms. Ventura, during what time period were you working as an RN?
And I'm sorry, I'm going to have to ask you to stop for just a second, Mr. Olson. I just have to pull one more thing up that I didn't have up that I needed. It should only take a moment. Okay, sorry, you may continue.
Do you remember my question?
Oh, I think you're on mute. I think you're on mute.
I became a registered nurse in 1972, and I still maintain a license. However, I have not worked in the acute care setting since approximately 2013.
At some point, did you tell Ms. Sherry to block Dr. Savitasen's calls on her phone?
Could you repeat the question? I didn't hear the beginning.
Did you tell Ms. Sherry to block Dr. Savitasen's calls on Ms. Sherry's phone?
I don't remember if I did. If there was a time period where I thought her calls were inappropriate, I might have said that.
All right, I'd like to show to the witness the document date stamped ERD 22, which would be in the respondent's exhibits.
Okay, you said it's going to be in the respondent's exhibits, correct?
Yes.
Okay. And I'm sorry, what was the Bates number that you gave, or the exhibit number?
It's 22.
Oh, okay, we don't have numbers. Okay.
Let's actually start with 21.
So this is Bates down. This is this is what you want, the memo here?
Yes.
Okay, so moving to date stamp 21.
This June 1, 2018 note to file, have you seen this before?
I may have, I don't recall it.
As Dr. Zavitazan's supervisor, would you have put this in her personnel file?
Yes,
And do you recall getting this around June 1, 2018?
I don't recall it, but I'd be happy to read through it.
Okay, go ahead and read it.
And just let me know when you need me to scroll down.
Okay. Could you scroll down, please? Could you slow down, please? I'm not finished with that paragraph, please. Okay.
Do you want me to scroll down from?
If there's any more, you could scroll down. Okay. Could you stop, please? Thank you.
The judge has to do it.
What's that?
She has to.
Could you move it up, please? finished reading it.
Is there anything in the document that you believe is inaccurately stated?
I don't know because I don't have access to all the information that it references. I couldn't.
Are you aware of anything that's inaccurately stated?
I'd have to repeat what I said. I don't know if it's accurate or inaccurate, unless I was involved in it.
Everything well, if there's something that you can point to that's inaccurately stated, I want you to do that right now, please.
Okay, could you go back to the top of the document, please?
I'd like the record to reflect that this is a note to the file drafted by Nick College, and it was dated June 1st, 2018, which is more than 2 years ago.
Could we go to the top of the document, please?
So what was the purpose of this? I have to object to counsel repeatedly coaching the witness. I mean, the document is what it is. I asked a very specific question, and then the legal counsel interjects, suggesting that the witness should not remember something. And she's done this repeatedly.
I'm just stating a
throughout the hearing.
fact.
Completely
I'm just stating a
improper.
fact. I'm stating a fact. It was prepared by
Well,
Nick
that's
College,
not
and it was
appropriate
dated June
objection.
1st, 2018. I'm not objecting. I'm just making a record of it.
Okay.
Well, you're not testifying, ma'am.
No,
All right.
I'm not.
All right. And I'm the one who's obviously reviewing this case, and I can see the date that it was prepared and who it was prepared by. Thank you.
I'd have to go through each line and tell you whether, as I recall, it was accurate or not.
Okay, then we'll have to do that then. Whatever labor you need to exert in doing this, let's do that.
I think I remember Bessa being very upset and down in my office. I don't recall her saying she's retaliating against me.
Anything else in the document you believe that's inaccurate based on your knowledge?
I'm going through each paragraph. All right.
So when you say that, Ms. Ventura, that you don't recall her saying that she was being retaliated against, are you testifying that she did not state that, or that you just don't recall whether she stated that or not?
I don't recall whether she said that or not. I know she was upset.
Okay.
Going off again. Apparently there was an issue with Dr. Sivadasan texting and disturbing Bessa, so I believe that to be accurate.
I didn't ask what was accurate. I just need to know what is stated here that you know is inaccurate.
Well, I have to go through and look at each one.
Please continue.
Okay. I don't recall, I can't say that it's not accurate because this is Nick's reflection, but could you keep on going down?
Sure.
Please.
Let me know when to stop.
Okay. Okay, could you stop, please? I don't, okay, you can keep on going. down the page. Okay, keep on going. You can keep on going. Could you stop, please? I don't know that any of it is inaccurate or accurate since I did not document it. It's Nick's reflection of what he believed to be taking place that day.
Throughout the document where it refers to Susan, that's you, correct?
Yes.
And you were in this conversation and meeting that he's describing, is that correct?
Yes.
And based on what you know, you've identified then what you know to be inaccurately stated, at least based on your memory. Is that right?
Based on the memo, I honestly don't recall discussing the STS data, but according to Nick's notes, it apparently was.
All right. And in the course of your job as an RN, have you reviewed STS data previously?
I have seen STS data. We did have an issue with getting the data into the STS database on a routine basis, and we have since taken steps to update our membership and assign staff to be able to document it correctly.
What is STS data?
Society of Thoracic Surgery data.
I'm sorry, can you repeat that?
Society of Thoracic Surgery.
And mortality, that rate that's identified here at two of the bullet points, what was the significance of that?
It wouldn't have significance to me since the rate is reflective of the volume. So you could have a higher rate, but because your volume of surgery is extremely low, you have to look at the absolute numbers to understand whether there's an issue or not.
Was that done?
Done at a committee level, that's not something I do.
The third bullet point says Dr. Trimark noted that Charnay shared that Dr. Zavita-Zan told her she was working on adjusting her medications to prevent a manic episode. Did you discuss that with anyone?
No, I did not.
The fourth bullet point concerning Dr. Zavita-Zan ordering neosynephrine. Do you know what the significance of that was?
No, I do not.
Did you, as a registered nurse for all those years, did you work with that medication?
Quite some time ago, it would have been in the early 70s.
Okay, not up till 2013 when you continued to be an RN?
No, I still am an RN, Mr. Olson, but I do not have an acute care assignment. And so if you don't stay in a particular field continuously, you cannot keep up with things.
Well, what I meant was you were working as an RN up till 2013, I think you said.
No, I was working as an RN with acute care assignments until 2013.
Okay, but not with that particular medication, is that right?
And I want to point out it was not with patient care, but supervising people in patient care.
Oh, okay. So your testimony is you didn't work with that drug since the 70s, is that right?
That's correct.
And then the last bullet point says Dr. Trimark indicated he believes that Dr. Zavita-Zan may be impaired It may be a risk to patients given this change in her behavior and practice pattern. Did Dr. Trimark discuss that with you and Mr. Galich?
I don't recall that, but
You know, can I just object for the record that we're not talking about other complaints. We're talking about, in this case, whether the complainant made a complaint. We're not talking about whether Dr. Trimark indicated he believed that Dr. Savadison may be impaired and may be at a risk to patients. We're talking about the relevant subject, which is what did the complainant complain about, if anything?
And Mr. Olson?
Yeah. Again, it goes to the veracity, the reasonableness of the complainant's complaint. This information was derived directly from a long documented list provided by Ms. Sherry to these administrators who have all had this convenient memory loss and Dr. Trimark. And based on that, he reached conclusions. So it's completely relevant.
Okay,
Okay.
I will respond by saying I take offense to the fact that you say a convenient memory loss, and I also take offense to the fact that we're not on the same page with regard to the continuing ongoing questioning of other people that may have had or not had a problem with Dr. Savadison. This is a case that's about what the complainant did or didn't do with regard to complaints that she made.
Okay.
If she did.
And I think, you know, I thought about this a bit last night, this morning, and I think that the problem, at least, you know, in my mind, stems from the fact that we're not starting with a complainant. And so I don't have her testimony yet, or, you know, her, you know, claims as to the complaints that she made, the evidence that supports that, or the cross-examination against that. So it's you know, at this point, it's, you know, it's hard for me to determine the, you know, whether this is relevant or not to, you know, the testimony that she's going to present without knowing exactly what that is. Is there, again, so a lot of this is hypothetical, is there going to be, I guess, again, this is really hard because, you know, the complainant hasn't testified. Is the respondent going to be, you know, questioning that the fact that her complaint was made in good faith? Or I guess that's what this kind of comes down to.
Well, my objection is based on the fact that there may have been other complaints by other people, but it's not relevant to the case. So once we get to
the only way I can see it being relevant is if the respondent, and you know what, I think we should need to have this conversation just with the attorneys. So can we do that? Can everybody else, can I send everyone else to the lobby? Let me do that. All right, I'm gonna, unfortunately, it looks like the only way I can do that is if I take the exhibit down. Okay, and see, on my end, it looks like I have Tom Kelly, Deborah Krakowski, Alan Olson, and Ben Hunt. Is that accurate?
Yes,
Is
Ben, are you there?
Okay.
Yes, I'm here. Ben is here.
Okay, so you're the 4142, and then I have star 37. So, all right, and then I have Tom Kelly. It looks like he's here as well. Is it necessary for Mr. Kelly and Mr. Hunt to be involved in these conversations?
I would like Mr. Hunt to be, because he is my law clerk who's second chairing me on this case.
Okay. So is it, I see that Mr. Kelly is muted anyways. Is it necessary for him to be involved in this conversation?
That's really up to Mr. Kelly. He might not be participating at this moment.
That's what I'm wondering.
If it's okay, can you hear me?
I can barely hear you.
If it's acceptable, I'd like to be part of the call as well, but that's up to you, Judge.
Okay, and you're not a witness, correct?
Yes, ma'am, that's correct. I'm not a witness.
Okay, yeah, you're in-house counsel. All right. Okay, so again, I think that's my, my problem at this point is that it's hard to understand, whether this is relevant or not without the complainant having testified. Obviously, I have the complaint, but that's, in these de novo hearings, I haven't, I've read the complaint but I haven't read through all the documents that have gone back and forth in investigation. So I don't know my reason, what I would consider relevant is if there is a challenge that, that there was not a good faith, complaint made, or that the complaint was, I don't know, not, believable, then I would say that evidence that others at the same time made basically the same complaints may be relevant, okay? Complaints that are not, on point with time, or as to, exactly what the complainant was complaining about, I do not believe those would be relevant. But that small set of, the same time period, the same claims may be relevant. Now, like I said, because we're going, about this adversely, it's very hard for me at this point to determine, what is relevant and what is not, without the complainant having testified. So I don't know what the respondent's, response is going to be. I don't know if, the complainant needs to make an offer of proof at this point, but that's where I stand. That's where my difficulty lies, okay? Obviously, with the retaliation cases, and specifically in healthcare retaliation cases, there's, very, the law is very clear, and there's just, like I said, there's just a small number of things that I would consider relevant, but that's where my difficulty lies at this point. So I don't know if we need to talk this out a little bit further. Otherwise, I guess what is going to happen is that I'm going to allow the testimony until I can determine that it's not in that small subset that I would consider relevant.
Okay, well, and I understand.
And at the point that I determine it's not relevant, I would not consider it.
Okay, and I understand, Judge. I think where respondent is coming from is that we could bring in, all kinds of complaints that were made against both.
And I'm not interested in all complaints
and
that were made against the doctor. I'm just, if there is a challenge to the complaint being made by the complainant, on the grounds that, it wasn't made in good faith, or it's, it wasn't believable, or it didn't meet, those standards, then, I would consider just complaints, from others that were basically at the exact same time, about the exact, regarding the exact same, issues that the complainant had. That would be the only complaints that I would consider relevant. And it would have to obviously go to, it couldn't just be a general complaint, that two people shared that, the doctor, said something nasty to them. I would have to obviously go to patient care as well.
So
the standards of the act.
right, and I understand completely, Judge. I think one of the problems in this case is that there were a lot of complaints made against both the complainant and Dr. Savadison, and it was a personality conflict. It wasn't necessarily
right, and that's your testimony, obviously, or the respondent will be testifying to. So that's your position, is that it was a personality conflict. And Mr. Olson?
Right. So everything that we're putting into the record is consistent with the complaint, the position statement by us, as well as the IDPC laid out very clearly. In this document also, Ms. Ventura told Ms. Sherry to share the STS data with Dr. Trimark. And then it goes on to say that Dr. Trimark stopped in after he reviewed the ST data and talked with Charnay and the analysis.
I think you're testifying at this point, Mr. Olson.
I'm explaining that this is not a separate complaint by somebody else. This is all derived from the meeting with these administrators who don't remember anything. So that's why we need to put it in, because this attorney has argued repeatedly that we have not made, we've not established that there was a good faith complaint made. These administrators keep saying they don't remember anything. And this document shows that as a direct result of the long laundry list submitted in writing by Ms. Sherry, that they had Dr. Trimark review the information. He did review it, and then he reached these conclusions.
Okay, so you're basically saying that this is the complainant's, this was her complaint, this meeting?
This is her data. Dr. Trimark confirmed it, communicated it to the administrators.
Okay, so you're trying to establish that this meeting is the complaint, the things that were stated.
That's my argument, is that's not the case. And I think that we're talking about other people that are making complaints about Dr. Savadison, which is not relevant in this case. And I understand, Judge, that you're saying that, anything that happened around the time that complainant allegedly made her complaint would potentially be relevant, but we could have, like I said yesterday, another 3 days just on the complaints made between the complainant and Dr. Savadison and complaints about each other. I mean, there was a lot of, I'm just going to be blatant about this, there's a lot of drama going on. And it was, they had a problem with each other, and we could spend 3 days on all of the issues that they had with each other. It doesn't mean that was a good faith complaint under the statute that we're dealing with.
All right. Well, I guess my preference would be for the complainant, to testify first, but I understand that that's Mr. Olson's decision. Just so it would be a little clearer for me going forward, exactly what testimony is and evidence is coming in from the complainant. That being said, I guess we're just going to have to continue going at this piecemeal, and given what I've told you, I'm going to have to make the determination as to whether or not the evidence comes in, and then as I write my decision, whether it's relevant. So it looks like this is going to be, I mean, I have no hope that this will end today. So
No, absolutely not.
Okay. Thank you
And
for
like
your
I said,
consideration.
yeah, and like I said, it's not any complaint that's, that we're going to be talking about. I know that yesterday there was some testimony as to, somebody else, wanted to remove service because they were being yelled at. Well, I don't think that fits the act. So it's stuff like that. The fact that other people are complaining that she was, that this doctor yelled at them, or, that she was difficult to work with in that way, that I don't consider relevant. It's just going to be that small set of complaints that directly confirm the exactly what the complainant, specifically complained to the respondent about.
Okay, thank you, Judge, for your consideration.
So, and at this point, I guess what you're sharing is that, this meeting, that Mr. Gallick met. I guess we're going through his memo of this meeting. You are asserting that this was, the complaint, or a big part of the complaint that the complainant made verbally, correct?
It was one of her complaints. It was the meeting during which she submitted the long, long list of infractions
Okay.
that were reviewed by these people and analyzed by Dr. Trimark, by their medical director, and
Well,
by analysts.
again, you're testifying
Yes.
for witnesses at this point. Would you agree, Judge Tollefson?
Well, I think both attorneys have done that, quite honestly. And also, they've both made accusations without making any motions or supporting evidence. I don't want to hear about convenient forgetting anymore unless you have some sort of a motion showing that this is inconsistent with deposition testimony. Same goes for you, Ms. Kriskowski. I understand this is contentious, that it has been contentious from day one, but I don't think that all the arguing back and forth is doing anything to get this case to a point where I can make a decision on it faster. So.
I understand.
All right. So, especially in the presence of witnesses, please try to limit your comments. All right.
Absolutely.
I can read the record. There's no jury here that you need to, make things clear to. I'm looking at the documents. I can see them. All right. Unless for some reason you notice that I am not looking at something correctly, there's no reason to state something for the record either. Okay.
Very good.
All right.
Thank you.
So let's try to go forward, understanding what I've said. I understand that I, unfortunately can't give you, clearer lines, but we're just going to, I guess, have to go through this. As I stated, but we're going to go through it. All right.
Yes, thank you.
Okay.
All right. And I'm going to let the two witnesses, well, the complainant and the witness back in. And we were on the record the whole time, so everything was recorded that we just said. All right. All right. Okay. So where were we?
I cannot see on my screen Ms. Ventura yet.
Can't either, but sometimes it takes a few minutes.
Okay.
There we go. Ms. Krakowski, are you there? Do we need to wait a moment for you?
I was just
Okay.
checking a text from my daughter.
Okay. So we all set to proceed?
Yes, thank you.
Yes.
Okay. I'm going to need to get the record, I'm sorry, the exhibit back up, unfortunately. Okay, is this where we will?
Yes. Ms. Ventura, this memo
And I'm just gonna,
says-
sorry, I just wanted to state one more thing for the record. Okay, I've considered Ms. Krakowski's objection, and I will consider it as we move forward. Okay, Ms. Krakowski?
Yes, thank you, Judge.
Okay. Go ahead, Mr. Olson.
Ms. Ventura, the memo says that you told Ms. Sherry that she could meet with Dr. Trimark to share the STS data with him. Do you recall doing that?
I don't recall doing it, but I don't disbelieve it.
Okay. Did you have an understanding that she did in fact share the STS data with Dr. Trimark?
I believe so, more through reading it than I do in memory.
I'm sorry, I didn't hear you.
My memory is only triggered by reading it. So if it says that was the case, then I'm not going to dispute it.
Okay. And then it says that Dr. Trimark stopped in after he reviewed the STS data. Was it your understanding that he came into a meeting with you and Mr. Galich after he looked at the data?
I recall Dr. Trimark in Nick's office, and I was in there for a period of time and left. And our offices are very close to each other, so I might not have been in there the entire time.
And then,
But I do recall a meeting with Nick, and I remember walking in the office, hearing some of it, and leaving. It might have been.
do you remember being there when Dr. Trimark was there as well?
Yes.
Okay. And then do you remember him coming in and talking to Ms. Sherry about his review?
I don't specifically recall that. I may have been there, may not have been.
Okay, and it says in the sentence above the bullet points that Dr. Trimark talked with Charnay and the analysts. Who were the analysts?
I don't know.
You know who they would have been categorically?
Objection to the word categorically. It's vague and ambiguous.
You know what I mean by categorically?
We have some staff who collects data. But I tell you who they were at that time? No.
And were you present when Dr. Trimark shared the information that is listed in these 5 bullet points?
I don't know if I was there the entire time. Like I told you, I don't have specific recollection of this, but I have no reason to say that it's not accurate.
Okay, do you recall Dr. Trimark saying that Dr. Zavidasan may be a risk to patients?
No, I do not.
Had he told you that, would you have taken any action in response to it?
I would have shared that with the chairman of the department and our president and CEO.
I'd like to show the witness Exhibit 29.
Bear with me.
This is ERD 294.
Okay, so ERD 294.
Yes.
Would that be in? And just bear with me while I get this into the record. Okay. 29. Is that the complete shot?
Yes, it is.
Okay. Made it a little bigger for the, there we are.
Ms. Ventura, were you involved in this job posting?
On this, no, not.
Were you aware that there was a job description for a open position for a physician's assistant to the title is cardiothoracic surgery at Froedtert South as of June 1, 2018?
I recall that we were looking for multiple positions.
Okay. And
Physicians or physician assistants? I'm sorry.
Physicians or
Okay.
physician assistants and nurse practitioners.
And this would have been to support Dr. Zavidazan?
Yeah.
And that person would have supported Dr. Zavidazan in lieu of Ms. Sherry?
No, I believe we were looking for multiple people so we could assure people could have their time off. And so that, the job does not become too onerous.
Who was the physician's assistant who assisted Dr. Zavidazan after Ms. Sherry no longer worked in the department?
I don't believe we had a.
I'm sorry, can you repeat that? I didn't get that all.
I don't think we had another physician assistant at that time.
Did you
Hiring a physician assistant with cardiothoracic experience is very difficult. We prefer to have a physician assistant and a nurse practitioner support in this type of office because they can perform different functions. A physician assistant can go into surgery to assist. And sometimes, depending on who we have in surgery, we have enough OR support staff to be able to do what a physician assistant would do to help a physician in surgery, a surgeon. Sometimes we do not, so it varies from time to time.
And why is it hard to find a physician's assistant with the cardiothoracic surgery experience, if you know?
I believe I missed your question.
I think you said it's hard to find people with that experience as a physician's assistant. Why is that, if you know?
It has been for us, yes.
Do the individuals with that experience demand a premium in their compensation up and above other physician's assistants who don't have that experience?
Can you repeat the question?
Do physician's assistants with cardiothoracic surgery experience command a higher rate of pay than those who don't have the experience?
I would say generally yes.
And I'd like the witness to look, please, at Complainant's Exhibit 78, which is found at ERD 590.
Hold on while I just get this into the record, and then it will move down to where you want me to, Mr. Olson.
This entire exhibit is captured on one page, I believe. So after you've read this, I'm going to ask you whether you recall getting this email from Dr. Zavitazan.
Don't specifically recall it.
You deny getting it?
No, I do not.
Okay. And this refers, it's dated July 19, and it refers to the Chardonnay situation. And she says, I was really scrutinized by a lot of people for taking her off of the cardiac surgical service. Do you know who scrutinized her for that?
No,
And it says that she had to meet with Rick, that was Rick Schmidt, and medical staff about her well-being and behavior. Do you have knowledge of that?
that's what she said in the email, yes.
Were you one of the individuals who met with her about her well-being and behavioral issues?
I was not.
She says, yesterday, you were all able to witness the bizarre behavior that I've been dealing with for the past year and a half. Did Chardonnay Sherry engage in any bizarre behavior on July 18, 2018, or any other date that you know of?
Objection to the vagueness of the word bizarre.
You know what the word bizarre is, so you know what that means, or you can tell us what you think it means. Did you ever see Ms. Sherry act in a bizarre manner?
Again,
Answer the
objection.
Well, do you understand the word bizarre, Ms. Ventura?
Of course I do.
Okay, then you may answer.
I don't know. I saw her very distraught. I wouldn't say bizarre, and I don't know what Dr. Zavitazan was referring to.
Okay.
I responded to her that I agree. I agree that we have a positive future moving forward, trying to stay on a positive.
Did you see Ms. Sherry act distraught on July 18th?
No, I did not.
And when you responded, you said, I completely agree, exclamation point, correct?
Yeah.
All right. That completes my exam.
Okay. I note that it's 11:33. I don't know if now is a good time to stop since we're in the middle of, I guess since Mr. Olson is done and then we have cross-examination. To start, I know that Ms. Krakowski has to check on her daughter. I know that I need to take a break, unfortunately, earlier than I thought we would. Well, I guess, you know, it wouldn't have been as early if we started at 9, but I guess it makes sense to do it now unless you think that it would be better to start a little bit of cross and then break and start again.
I'm fine with taking the break now, especially because I do need to check on
Okay.
my daughter.
Your
All
Honor,
right. Yes, Mr. Olson.
yes. Do you rule on whether counsel is permitted to talk to an individual who's in the middle of their examination?
Well, I mean, we broke yesterday. So are you asking, I mean, we're going to have to break, and I don't believe that we're going to complete this witness before we need to take a break at some point. So are you asking that if we continue now and break, would Ms. Krakowski be prevented from talking to the witness, or are you asking if she would be prevented from talking to her now?
Talking to her while her examination is going on now during any other times.
That's why I tend to prefer to take breaks at these places versus in the middle of testimony. Does that answer your question?
So she's permitted to speak to her now, but not during subsequent breaks as her
Well,
testimony goes on?
I mean, I would caution against, but I don't think I can prevent it. So I guess what I would say is let's take the break now so that if you're concerned that Ms. Krakowski is going to talk to her witness in the middle of testimony, we can avoid that issue. All right.
Okay.
Does that satisfy you, Mr. Olson?
Yes.
Okay. All right. Then let's see. Do you believe 45 minutes will be enough time to break
I would
eat lunch for
prefer,
everyone?
I would prefer an hour because I need
Okay.
to
All right.
attend to my daughter.
Let's reconvene at 12:30. Okay.
Okay, thank you, Judge.
Thank you.
Thank you.